Okay, so thank you very much for joining us for the webinar. My name's Oliver Ingham. I'm a member of Chambers here, specialising primarily in probate work. I'm hoping that there aren't any technical issues and that nobody's having any difficulty hearing or seeing me. And hopefully I'll be told if any such issue pops up. I should say at the very beginning, the purpose of the webinar is to be a little bit interactive, and we're inviting questions and hopefully answering most of them towards the end. There is, or there should be on your screen, a Q&A button which allows you to ask questions. I believe it also allows you to see the questions that anyone else has asked. And if you have a question, you can put it in there and I'll do my best to answer it during the webinar. And if we don't get to it, I will do my very best to contact you with a written answer within reason, of course. But thank you very much for joining us. And the purpose of the webinar, and the reason that we wanted to put on the presentation, was because of a recent case that I was instructed in called Kaur and Singh. You'll often see it referred to as re-estate of Karnail Singh as well. And it was before Mr. Justice Peel, who is the National Lead Judge for Financial Remedies of England and Wales. And that was one of the reasons I think that he wanted to write this judgment in particular. The facts of the case are interesting. The application of the Inheritance Act is not particularly controversial, and the, if you like, interest that can be drawn from the case is not really in the factual background, but just to give context, this was a spousal claim brought by a widow who had been married to her husband since 1955. They had been married together and lived together in the Birmingham and West Midlands region for all of that time. It transpired when the husband died that his will had left his reasonably substantial estate. It was thought at the beginning to be about £2.5 million, coming mainly from a business and a factory that they had owned. It was thought at the beginning that his estate was relatively substantial, and in his will he left his entire estate to his two sons. The position that was prevalent when we found the need to bring proceedings was that, as you will see if you read the authority, one of the sons was supportive of our position, which was that we wanted to secure relief for essentially the mother, and one of the other brothers was not involved in the claim, but was ostensibly hostile to it. So in terms of the factual background, it was a reasonably standard, straightforward spousal claim under the Inheritance Act. And indeed, it's difficult really to think of an example of a case where an award could be more appropriate. If you have an opportunity to read the judgment, that's not very long, and the factual background is also not very long either. It is interesting from that perspective. There's quite a lot of press summaries about it. There is also summaries, I believe, on the BBC and on ITV. If you apologies. If you're interested in the general factual background, the reason that I wanted to have the talk and deliver a talk in this format was because for practitioners and from a practice perspective, the interest isn't really so much in the legal principles or the factual background to the case. It's the practical aspects of it, and also the I suppose principles that can be derived from it for future. What I mean by that is this was a claim, of course, where there wasn't a trial. We were able to get judgment at what in any other civil proceedings would essentially be a summary judgment application hearing. So The practical significance, if you like, is that the judge used the opportunity to go through the circumstances in which it might be appropriate to use what he calls an abbreviated procedure, which really is just the Part A procedure as it applies to Inheritance Act claims. The reason that's important, I think, will probably be exemplified by the practical issues in this particular case. So there may be many circumstances in which a party is seeking to bring a claim under the Inheritance Act where they are extremely elderly. And I'm not talking specifically of my client, the claimant in Kaur and Singh, but one can imagine a person with those characteristics and circumstances may well find themselves in a position where there is sadly a real risk that they may not survive if the proceedings go on for a very long time. And indeed, there's a number of cases I'm dealing with where I can think that the claimant, or in some cases defendant, is extremely old, just because, of course, that is the context that a lot of the spousal claims arise in. So the first thing is that there's an issue, of course, with the age and vulnerability of some of the clients. So the emphasis here, where you have a claimant in that position, especially where there isn't sign of there being a full-on dispute that's going to need to be resolved at trial, is obviously to have the matter dealt with as quickly and efficiently as possible. So in the case of Kaur and Singh, the way in which we chose to do that was to issue the claim alongside an application for summary judgments, and also for what was described in the judgment as summary determination under CPR Part 8, so that we could have the court deal with the matter on the first available date that the case came to be heard. There was a directions hearing listed, I think, about 8 weeks after the claim was filed. In certain circumstances, it's possible to get it earlier than that in the family division in London. And the objective was to make sure that we didn't have the, if you like, the wasted time of a directions hearing in circumstances where one of the defendants was supportive of the claim and the other, whilst ostensibly hostile to the claim, hadn't actually engaged or taken part by filing an acknowledgement of service. The, if you like, the difficulty that perhaps one might want to avoid can be seen when comparing the position in this case, Kaur and Singh, to an earlier case which is mentioned in Kaur and Singh. It's called Re-H 2020, which incidentally is the first instance decision of what is now called Hirachand and Hirachand, which is going to be resolved in the Supreme Court later this year, and on which I'm being led on. But the first instance decision is only being appealed insofar as it relates to the CFA inquiry. The rest of it is not controversial. But that was a case in which Mr. Justice Cohen was prepared to look at the claim without having a trial, and just by essentially having a day-long hearing. The difficulty there was that came after, I think something like 18 months of attempts to have the defendant file their acknowledgement of service correctly. There were various unless orders made, and in that case, the claimant was not at risk of passing away, and there wasn't any particular reason beyond financial need why there would need to be any expedition. However, it is important, I think, where you have a case like that, where there's not going to be an active defence, that you are able to try and have the matter dealt with on the first occasion, if at all possible, to avoid this situation that arose in Re-H, where you have hearing after hearing after hearing, where, yes, cost orders are being made against the defendant who is not complying with an unless order to file an acknowledgement of service, but you are wasting a large amount of time, especially also in circumstances where the defendant in that case haven't acknowledged service. So it would have been possible, potentially, maybe not in that particular case, because obviously everything turns on its facts, but in most scenarios like that, where there's repeated non-compliance by a defendant, it is obviously desirable if you can simply proceed and get it over and done with, rather than trying to coerce the defendant into defending the claim. So that's the aim, if you like, and that's the motivation that was behind pursuing this claim in the manner it was pursued. In short, there was, as I've said, the claim issued. At the same time it was issued, there was an application issued for summary judgment / what we called summary determination under CPR Part 8. We then asked, or my solicitors rather than asked, the family division to list a hearing. It was able to do so relatively quickly, and we were on before Mr. Justice Peel, who I think took something like an hour and a half to deal with the claim. And in so doing, in his judgment, he helpfully set out, as I said, what he calls the abbreviated inquiry. So what I'm hoping to do is go through first of all, go through examples of where this kind of approach may be appropriate and where it won't. Also talk about the preparation involved in making an application like this, and what can be done to try and ensure that it does come on in the way that you want it to, as opposed to being subject to delays and directions hearings. And then finally, I'm going to just very briefly touch on some of the comments in the judgment that are made about reforming the error generally, or reforming the procedure and practice generally. If you do have the opportunity to read the judgment, you'll see that there is a section in there which essentially talks about proposed reforms to the way in which the disputes under the Act and Family Division should be dealt with in future. So turning first then to this idea of having an abbreviated claim, or a summary determination of a claim, the first consideration for whether or not a dispute is going to be suitable for this sort of determination is obviously to look at the extent to which it's disputed, if it is disputed, and if it is disputed, what those disputes are and whether or not they go to the criteria under the Act, or whether or not they concern matters which need not actually be resolved at trial. The most common situation in a lot of these claims is where there's non-engagement from one particular necessary relative, or be it a son, daughter, or other family member. Very usually, there is an ability in a lot of these claims with families, especially spousal claims, there is an ability to reach an understanding between the family, and it can often be the case that there might be one or two individuals whose permission is required, either because they are beneficiaries or because they are taking under the intestacy rules. And yes, they're either not engaging, or are, if they are engaging, but not doing so in a productive or helpful manner. It's important to be clear that the process and the procedure is not going to work for any cases where there is a serious bona fide factual dispute. So, for example, spousal claims are obviously one example of an area where there tend to be fewer factual disputes. But there are, of course, other categories of claimants, such as cohabitants, most particularly, where there's a precondition that they have to prove before they're entitled to have an order in the first place. As you'll know, with cohabitant claimants, they have to show that they were living with the deceased as man and wife for more than 2 years, to give an example. And very often in those proceedings, it can be the case that there is a challenge to that qualification, e.g., no, they didn't live with them as man and wife at all, or it might be that they didn't live with them for 2 years. In that kind of situation, there is always going to need to be a trial, assuming that the parties are all litigating properly as they would be expected to. And it's not going to be possible for the matter to be dealt with by, for example, summary judgment or any kind of summary basis, because obviously a judge can only determine a question like that or a factual threshold by hearing evidence at trial and hearing cross-examination. The same can be said to some limited extent with adult children claims, where there can often be factors which are relevant for the exercise of discretion, but where there is factual dispute between the parties. And if all of the parties have put in an acknowledgement of service where they say they're contesting the claim, and they set out, even really the barest factual rebuttal or defence, it is unlikely without their agreement that you will be able to have the matter disposed of summarily, because obviously that isn't the standard way in which the claims are dealt with, where there's a factual dispute. Incidentally, if the parties do agree, of course, that becomes much more easy for the court to resolve, because where the parties agree, you can ask the court to determine the matter on the papers or on a summary basis at a hearing, but it's probably not advisable unless it's clear that that there's nothing to be gained from a trial, or where there is, as I say, big scope for agreement between the parties as to what the judge is deciding and on what basis is being decided. Some parties are able to do that in claims where, for example, the factual disputes relate to ancillary matters which don't really matter, and which one could call, for example, mudslinging, but don't go to the criteria under the Act so much. And in that situation, if the parties can be convinced to do so, then the court can deal with that consensually without having a trial. But where the parties don't agree, obviously it's not an option. The times in which it will be most suitable, I believe, personally, are in spousal claims where there is an obvious strong claim. And you'll know, if you do Inheritance Act work regularly, that claims under the Inheritance Act brought by husbands and wives and civil partners are subject to a different standard than the rest of the claims. They're entitled to reasonable financial provision, whether or not required for their maintenance, e.g., you don't have to show that the money is needed by reference to like a financial shortfall in earnings and expenses, or some other financial justification doesn't need to be made per se. That the focus is very much on the so-called divorce cross-check and taking a view as to the likely outcome that there would have been had there been a hypothetical divorce. And because those claims are different, and because it is very easy to discern whether someone is married or not, you either usually are or are not married, and that doesn't very often appear as one of the disputes that arises in these sorts of claims. It's usually obvious from the outset that the claimant is going to qualify for a claim or for an order under Section 2 of the Inheritance Act. The question is just how much they're going to get and how large the award might be, or what type of award they might get. In many of these sorts of cases where the dispute isn't to do with, as I say, factual qualification, and is more to do with finances, it may be possible for you to try and obtain an outcome by making an application for summary judgment or summary determination along the lines set out by Mr. Justice Peel in this judgment. There are limitations to this approach, which obviously need to be balanced quite carefully against the benefits. So this case involved, of course, a very elderly woman who was very vulnerable, and it was extremely important that the claim be dealt with as quickly as possible. In the end, I believe it was between 10 and 12 weeks from issuing the claim to judgment and conclusion. There may be scenarios in which it's more urgent than that. But there are obviously difficulties and, if you like, trade-offs that are going to arise when that approach is taken. And that can actually be seen in Kaur and Singh itself. So if you read the judgment, you will note that the claimant's claim was essentially just put very basically on the basis that she wanted half of the matrimonial assets / half of the estate. The court doesn't usually, as standard, deal with Inheritance Act claims by looking at what portion it thinks a party should get, because it's not that kind of analysis that's applied under the Act. That's not to say that there aren't scenarios in which it will be appropriate, but usually because the court is looking at financial provision, which necessarily is fact specific and involves looking usually at people's income needs, housing needs, etc., applying a sort of blanket percentage doesn't tend to work very well. I think the reason that it had to be done here, and the reason that there's the trade-off, if you like, is because in many cases, especially where you don't have as much engagement from defendants, and possibly you're not even sure what the full extent of the estate is, it's very difficult to know exactly what the form of award is that you would be seeking, where there is either non-disclosure in relation to estate assets, or, like in this case, not non-disclosure, but just a lack of just general information because the parties are lay parties and they're not using professionals to assist them in obtaining probate. There are many number of examples where this can arise, and particularly in cases where there isn't even a grant of probate yet. So in Kaur and Singh, probate had not been applied for. The parties had a very rough idea of what they thought was in the estate. They obviously had an idea of the minimum that they knew was in the estate because of the properties that were consistent therein. But even in this case, the variation was something like between 1.2 and 1.9 million pounds, so quite significant. In an ordinary circumstance, in an ideal world, assuming, for example, that the claimant in this case, or a person with the same characteristics, wasn't as vulnerable and perhaps could afford to wait longer, and or it was just a different scenario in which it was possible to wait longer, I would personally rather not approach a spousal claim on the basis that the court simply asked to give half of whatever happens to be in the estate, because first of all, of course, that's not as satisfactory where there are question marks over how much the estate is worth. Again, it's a little bit different here because they could identify at least, I think, about 1.2 million pounds of property, definitely. So to that extent, there was going to be, whatever the position was, a substantial sum of money available. But one could easily see a position where it may look like there is a reasonable level of capital and liquid capital within an estate, and that actually turns out not to be true for whatever reason. So ordinarily, one wouldn't want to pursue a claim for a spouse, especially one of 66 years rather, because, as I say, it's not particularly forensic. And very often you are able to justify, and the facts do justify, having an award which is worth more than 50%. Of course, that is just the broad brush starting point in relation to claims like this. Looking at white and white, which people who are in this area will be familiar with, the divorce cross-check, the half and half equal provision starting point isn't a hard and fast rule, obviously, and usually you would want to have a scenario where you can go through estate accounts that have been published properly in good time, and where you can interrogate the size of the estate and the nature of the assets that are available. I should say one of the other relevant factors in this case, which made it simpler for the claimant to want to just seek 50%, was that usually one of the main assets that's in contention for a spouse is the matrimonial home. In this case, the claimant had been removed from her matrimonial home, and one of the sons was living in the home in her stead. And that ordinarily would of course be in a highly unsatisfactory state of affairs. But the facts were such, and her position as communicated to the judge was such, that she did not want to own the former matrimonial home. She didn't want to go back there. So in that instance, it was less problematic for the lawyers to essentially approach the case on the basis that they would ask the judge to just award half of the assets that were available. Usually that won't be the case, and as a minimum there'll be the former matrimonial home that will be the centre of the dispute, if you like. The other reason it's not ideal is because when one is making an application for a spouse under the Inheritance Act, ordinarily you will want, of course, to have an award or argue for an award that's tailored specifically to their needs and specifically to their particular circumstances, which employing the sort of blunt edge of using percentages is pretty difficult to do. So there are drawbacks, and of course the reason that those are drawbacks which have to arise if one wants to proceed in this basis is because at the first hearing of an Inheritance Act claim, or at the very outset where there's no grant of probate, for example, you're not going to be able to go into much argument about the size and nature of the estate. The information may well be too thin on the ground. So it will be a matter for the parties, and a matter for the client particularly, as to whether or not they wish to essentially balance speed and efficiency and keeping costs down with the concern that they may not get as much as they might be entitled to, or they may not have an outcome that would be the same as if they were able to have not even just a trial, but a full hearing. So, for example, in Re-H, there was information about the nature of the estate, and that was a case where they were severing a joint tenancy. So there was a lot more information available about the exact financial position. And as I say, that was listed for a whole day. Even that's preferable, but it will depend, of course. And as I say, if you have a client who is very unwell or very old, and where there is a real serious risk that they may pass away during the proceedings, then it may just be something that they have to accept as a compromise for having the matter resolved quickly and amicably. The other situations in which it may not be suitable are where the dispute is such that there needs to be a lot more argument about the size and nature of the estate. Obviously, if there are allegations that the defendant's executors, whoever it is that's managing the estate or intending to eventually manage the estate, the disputes about hidden assets, non-disclosure, anything of that nature, then clearly that's not the sort of thing that is going to assist with having a summary determination or an abbreviated determination, because obviously those are issues that will need to be resolved as a preliminary issue if they are pushed to their fullest extent. My most recent example of that was the case before Mr. Justice Francis, where my clients were the claimants. They were minor children, and there was an allegation that the executor had misappropriated, with probably not the correct word, had transferred with the consent of the deceased on his deathbed the sum of about £600,000 into a bank account. So obviously that wasn't in the estate for the purpose of the claim being litigated, and we couldn't go any further until essentially we got that money back. So that was the preliminary issue that we had to resolve first. That kind of thing obviously is not going to be suitable for summary determination slash an abbreviated inquiry. I just want to also talk a little bit about the crossover between the Inheritance Act and summary judgment and the so-called abbreviated inquiry, because they are different. So obviously summary judgment, the principles will be well known to everyone, and they don't change when applied to a claim under the Inheritance Act. Obviously, they're a lot more difficult to apply in some circumstances, but you are still fundamentally looking at whether or not the claimant or defendant, as the case may be, has a reasonable prospect of making or successfully defending the allegation. That's not the same with the so-called abbreviated inquiry. I mean, just to read what Mr. Justice Peel said, and this was the basis on which it was put to him in written submissions, because it's a Part 8 claim, of course, it's designed for the determination of claims without, quote, elaborate pleadings, without disclosure exercises, without trial, etc. If there are no issues of fact, then the claim can be determined on the written evidence. That is just a case of looking at the written evidence at the merits in the same way that you would do in any other case. There's no threshold, and Re-H is an example of that, where the Mr. Justice Cohen takes the parties through the criteria in section 3 and makes a judgment about each of them. And that's just done on the normal basis that the claimant has to prove their claim on the usual civil burden. That's not the same as summary judgment, where of course there's a raised burden because you have to demonstrate the threshold is met in CPR Part 24. You might wonder what the point of asking for both is in a case where, for example, you don't have an active defendant, or where it's very clear that there's no real factual dispute. The reasons to ask for both are as follows. The difficulty can sometimes be that we're never sure who is going to turn up at, for example, the first hearing, or what they're going to say if they do. So to take this case, for example, there was every chance that, for example, the son could have attended. That could have been to oppose the claim more generally. It could have been to ask permission to participate under CPR Part 4, 8.4, if he had counsel and was a bit more focused. There could be any number of different things that a defendant might do. And one of the reasons that we chose to have both heads of claim in both the original Part 8 claim form and in our application notice was because if there was no engagement and no acknowledgement of service, then of course we could ask the court to deal with the matter in the way that it did. So essentially just looking at it on its merits by going through the papers. And if the defendant or any other person defending the claim turned up and was able to assert reasons why they should be given permission, which usually it doesn't take very much given the nature of these proceedings, it is useful to be able to fall back on the summary judgment provisions, because that is something that a judge can consider in the alternative, and which, if the defendant is engaged properly, they should have engaged with before the hearing. You'll know that there is a timetable set out in CPR 24 and in the practice direction to Part 24, which says when the evidence has to be done by the respondent. And that's the same here with Inheritance Act claims. And you can, to an extent, manage the risk of a party sort of turning up on the day. So that's a reason why both, I think, should be cited in suitable circumstances. There isn't really any examples apart from this case, and then also a case called Delal in 2015, which deal with summary judgment as it applies to Inheritance Act claims. Delal is not very helpful either, because although it mentions that there is an application for summary judgment, it doesn't actually determine it, because that wasn't the purpose of the hearing that the parties were at, and it wasn't the purpose the judgment was written for. and I understand that Dal and Dal settled shortly after that anyway. So we don't have an authority which has the summary, as far as I'm aware anyway, that has the summary judgment criteria being specifically applied to an Inheritance Act claim. Mr. Justice Peel said in this case that he safely could have made an order for summary judgment, but there isn't an example of any authorities in any 75 Act case where there actually is the analysis and application of the individual summary judgment criteria. The only, as far as the summary judgment side of things is concerned, the only comments that can really be made are clearly it is more difficult to apply the summary judgment standard to a claim under the Act. Usually it will be considering whether or not a defendant has a realistic prospect of successfully defending a claim or issue. And I would have thought that normally that will be that can be a flexible question depending on what it is the defendant's trying to do. So as you all know, with claims under the Inheritance Act, the claimant makes the application for an order under Section 2. They either are given an order or they're not. If they're given the order, then failing other criteria and factors, they're the winner. And they only have to get something to be the winner generally. The defendants, obviously, to be the quote winner, have to have the claim dismissed. And this is why you have so much importance and focus in Inheritance Act claims put on settlement and offers and Part 36, because it is an area where the defendants are in a particularly difficult position just because of the inbuilt imbalance in the Act between claimants and defendants. So insofar as the defendant's concerned, if there's no participation from them at all and they haven't said anything, then it seems to me entirely proper to put the application on the basis that the defendant doesn't have a reasonable prospect of showing that the claim will be dismissed. And that's what we did in this instance. And if the court is satisfied about that, then that there isn't any reason why they can't then go on to make an order and to make an award in the way they usually would. It becomes more difficult when the defendant's position is more nuanced. And indeed, if there is any nuance in the defendant's position, it's probably a sign that summary judgment, summary determination generally is not going to be suitable. But at the end of the day, the reasonable prospect threshold will essentially apply to whatever it is that they are saying or whatever level they're setting as their positive case. I mean, you may have certain circumstances in which they set out a positive case that they want to protect or keep a certain property, portion, part, whatever. And obviously, if you're judging that against the summary judgment standard, then that needs to reflect what they describe essentially as being their case or the outcome that they want. Overwhelmingly, however, if there are properly represented defendants and claimants who are submitting an acknowledgement of service that has evidence with it, the starting point probably is that it's not going to be suitable for this sort of determination for obvious reasons. So in terms of just some practical points about what to do in preparation for trying to make a claim like this one. And when I say like this one, I mean a claim where you have a client who has a prima facie very strong Inheritance Act claim and there's no real formal or proper response to it from any defendants. The choice in this instance, because it was a spousal claims to file in the family division, obviously family division, the business and property courts and the county court all have jurisdiction to deal with any claim under the Act, regardless of its size, regardless of the type. However, there is a general practice in London specifically, I would say, that spousal claims are usually considered to be more suitable for the family division, with the other claims more suitable for the county court in central London. These days, essentially no claims are suitable really for the business and property courts unless they have a very substantial a value or there's some very substantial complexity to them. But the family division is obviously the one which I'm concerned with in relation to this case. And I would suggest as well, it's probably the one that is much more flexible and which is much more accommodating of attempts to dispose of cases in an abbreviated or summary where it's appropriate. That's not to say that they are more or less strict. I don't believe that at all. But the way in which the family division operates, even just administratively, I think probably is better than the business and property courts. It's also worse in some ways. So, for example, in the family division, there's obviously no junior level of judiciary. There's no masters in the family division, which is something mentioned in the judgment I'm going to come back to. But the judges are all full-time High Court judges. And that is obviously good from the point of view that they're obviously experienced and able to deal with the issues that you're going to be raising, but bad in terms of sometimes in terms of speed and availability, because of course the absence of the more junior level of judges, e.g. the absence of having a master in the family division, I think sometimes can mean that things take longer to get on. But in any event, in the family division, as I say, in London anyway, the court office can receive the claim form along with an application for summary judgment / summary determination. It is possible usually either by calling them or attending at the office, which is, if you've been to the Queen Elizabeth building in the RCJ, it's on the first floor. And they will, when you've issued the claim, set down a hearing, usually a hearing date pretty soon. Sometimes it has to even be moved back because they set it before the deadline is up for filing an acknowledgement of service. But when the claim is issued in in the London Family Division, they will issue a hearing pretty quickly. And in order to make sure that hearing is effective, as it was here, it's necessary, obviously, to first of all have regard to the practice direction 27A to the family procedure rules. Now, I don't know, of course, it will depend from practitioner to practitioner how familiar you are with either the CPR or the FPR. Obviously, I mean, predominantly I'm a chancery practitioner, so I almost never come across the family procedure rules, except for in this instance, which is that in the family division, the CPR still applies, but there is one exception. It is the application of practice direction 27A of the family procedure rules. So there's a mixed approach to the procedure rules. I actually think it's a good thing. The reason I think it's a good thing is because the practice direction 27A of the family procedure rules sets out quite a detailed but simple approach to setting the case out as between various preparatory documents. So in the business and property courts, of course, it's common for parties to do a skeleton, and there'll be other documents they might provide, but there isn't a practice of, for example, setting out the case in accordance with particular headings, like having a very short case summary that's confined to a certain number of pages, having the list of issues in the same document, having position statements dealing with factual disputes or skeleton arguments if they're appropriate. I find that the way in which the documents are prepared in the family division makes it easier for the parties and the judge to come to grips exactly with what they're dealing with. There's also other safeguards, such as, for example, in the family division, if you're counsel, that there is provision for calling or contacting the judge's clerk beforehand to check that they have everything, and that's an obligation on counsel as opposed to solicitors. And I find actually that does, when it's followed anyway, tend to mean that there are no sort of administrative issues on the first day or the day of the hearing, which obviously you don't have as much flexibility with that sort of thing in the business and property courts. But in any event, they can be asked to list the hearing. If, as long as the parties comply with practice directions, Part 27A, and it's clear what the ambition is for that hearing from the outset, there shouldn't be any difficulty in being able to wrap it up at that first hearing, provided, of course, that everyone has been served and that there isn't, like in this case, or in Re-H, there isn't any scope for arguing about the underlying merits as of factual disputes. Before just taking some questions, I just also wanted to refer to a part of the judgment, and I think the reason that Mr. Justice Peel wanted to do the judgment was because there has been this slightly odd lacuna where claims brought in the family division in London in any event are always dealt with in the Queen Elizabeth buildings by full-time family High Court judges, who would usually be dealing with either finance claims which are worth more than £15 million, as in divorce finance, so which doesn't really arise and is quite rare for those to go to hearing. So the financial remedies judges in the High Court don't very regularly have to deal with contentious ancillary relief proceedings. Obviously, they're preoccupied with very urgent, important children law type applications, especially where it concerns things like international abduction, adoption, the very big and weighty cases about withdrawing treatment, etc., is what they're used to dealing with. And it is a bit of an anomaly that when the claim is brought in the family division in London anyway, there isn't really any way for the court to feed it down to a lower tier of judge, with the exception of, I mean, they could transfer it to county courts of central London, but they don't. That hasn't been something that I've seen that they want to do. Mr. Justice Peel addresses it in the judgment and just explains that the background to that, and points out it's slightly odd that cases issued in the family division, he says, have to be heard by a High Court judge. Outside of London, incidentally, if you are dealing with a district registry in Birmingham or Manchester, Liverpool, Cardiff, Bristol, it invariably won't be a family division High Court judge that deals with it. It will be allocated probably to a deputy or a circuit judge that is also a family ticketed circuit judge. So it's only really a London problem where there's only High Court judges that deal with the claims issued in the family division. But essentially what he says is his hope is that there will be amendments so that the claims can be brought in the family court proper, e.g. in exactly the same court that you would make ancillary relief applications. I don't know enough about the ancillary relief jurisdiction and, for example, the Principal District Registry or the Central Family Court in High Holborn. I don't know enough about it to know whether it is quicker, more efficient, or better in any way than the Central London County Court. If it is, then obviously that's something that may be positive. On the other hand, I think that when I was doing research recently for a book covering some areas that are relevant to the Inheritance Act, I was able to obtain the data about the number of these claims which are actually issued in the High Court, and it's very few. I think there's only a handful every year which are issued in either jurisdiction in London specifically. So I mean, it may well make not much difference at all. But what Mr. Justice Peel says is that he thinks that they should be brought in family court proper, dealt with in the High Court if they're worth more than £15 million. That would bring it into line with divorce work. And I suppose that's part of a more general move that one can see, actually, including in some of the more recent appeal cases of, if you like, a desire to try and move the Inheritance Act fully into the family procedurals and the family jurisdiction, which there'll be different opinions on. Obviously, some people will think it's more appropriate, others will not. I think that from experience, the majority of lawyers that deal with these sorts of claims are not family litigators. or divorce litigators. So it probably would be quite a big change. But in any event, it's interesting to just see what his views are about how the jurisdiction should change. I would have thought that they are comments which are likely to be acted upon at some point. So we may have to just see what will happen there. But yes, to very briefly summarize and conclude, the case is interesting from a factual perspective, but it is more useful as a guide to when it will be appropriate to obtain essentially summary judgment, summary disposal of an Inheritance Act claim very quickly, without having trial, without spending lots of money. And hopefully it will become clearer if more claims are dealt with in this way. The edges of the jurisdiction might be more clearly demarcated. I'm just going to now look at the question and answer box. I'm sorry that I overran because I did say that I was going to finish at 1:45, and there are quite a lot of claims. So I'm just going to take them in order because they all are different from what I can see. So one of the questions is, how would an Inheritance Act claim deal with a will that left everything to a discretionary trust with the spouse a beneficiary of that trust? I mean, obviously, everything is going to depend on the individual facts of the case. The fact that I mean, I'm assuming that the sort of hypothetical is a situation where a spouse is cut out, if you like, of a will in the traditional sense, but then maybe they're a beneficiary of a discretionary trust where, I don't know, the trustee is terrible or they're not giving them anything. The fact that they are a discretionary, they're a beneficiary of the discretionary trust does mean they could still bring the claim in principle. You'd also have the other possibilities, such as maybe a Part 64 claim, application to remove the trustees if they're being badly behaved. But I think it would depend on how easily or not the spouse would have access to the funds or assets or whatever it is in the discretionary trust, because if they don't, then I suppose that is, if you like, the complaint that will be made, and that's the way in which it will be said that the will fails to make reasonable financial provision. I would have thought there'd be quite a lot of thinking to do there, though, about alternatives to the Inheritance Act, e.g. removing the trustees, because if they are, then equally it may also depend on how many other co-beneficiaries there are, because if they are but one of many, then clearly the Inheritance Act will be appropriate. If the model of having the discretionary trust puts their home at risk, it will be appropriate. There's very many different types of scenario where it will still be appropriate. And I suppose it depends on the practical consequences that arise from whatever the model is in the will giving rise to the discretionary trust. So that's the first question. The second question is to do with cohabitation claims and whether they are more suitable generally for the county court. Many firms in London that do more regular Inheritance Act work tend to have all of the claims, cohabitant or spousal claims, issued in the family division, just because, again, there's a perception that it's more generous, which I'm not sure is true. I think it depends on the individual judge. But there's also a perception, which I think is true, that it is faster and more efficient. I wouldn't say they're necessarily more suitable for the county court. However, they would definitely be more likely to be sent down to the county court, because the reason that the divorce claims are the reason that the matrimonial claims are kept in the family division is because the guidance specifically says that they're suitable for the family division. It's repeated in the case I've been talking about, Kaur and Singh, but the Chancery Master's transfer guidance from 2015 says that the Inheritance Act claims bought by a spouse will usually be suitable for transfer to the family division. That's if you've got a Chancery Master thinking about transferring it. And then also in the Business and Property Court's advisory note issued by the Chancellor on 13th of October 2017 says exactly the same thing. and that's not been revisited since. So usually the reason, or if you like, the justification that parties use for having their spousal claims issued in the family division is that obviously that doesn't apply to any of the other claims. So I mean, it could be said that there's less justification, and they may well be more likely to, if you were to issue it in the High Court, then may well be more likely to transfer it out. In terms of the actual outcome and whether it makes any difference at all, even in the county court, the Inheritance Act claims can't just be heard sort of anywhere. That they are only heard. I mean, in theory, they should only really be issued at what used to be called chancery trial centres. I don't think they use that language anymore. But there's a list of courts in the CPR which are appropriate for issuing business and property claims, which obviously includes the Inheritance Act claims, and that will be the likes of like Central London, everywhere that has a High Court registry, Oxford, Cambridge, to come to mind as centres, but not, for example, your local county like Bromley County Court or some sort of local county court that deals more with common form business, personal injury, etc. So yeah, you will still usually have a probably specialist CJ as a minimum, whatever the court, whatever level of court it is. So the next two are slightly longer, and I'll just see if I can try and summarize them. Because what I will try and do is, if there are ones that are slightly more bespoke, e.g. they're sort of factual scenarios, then I may try and see if I can write an answer to those rather than reading them, just because they're not a sort of general application. So there's another question as well, just to finish off, and I will write in relation to the other ones. But there's another question which is about this distinction between bringing in the Chancery Division or the Family Division if you have a claim in the Inheritance Act, both in and outside of London. There's been a long running discussion about which of the types of court and which types of judge are not more likely to be, if you like, softer or harsher in various different circumstances. It was traditionally thought, for example, that the Family Division was a lot more lenient on claimants and a lot more pro-claimant. And there are some examples of cases where, you know, I can see why people would form that view. And it's traditionally also been thought that the Chancery Division is harsher and not as lenient and is more pro-beneficiaries, pro-property rights. My experience has actually been the opposite. To this extent, I found that because the family judges, I should say, first of all, I don't endorse this as being a factor that should be taken into account at all, because obviously you can never know exactly what's going to happen and which judge it's going to go to. But just because the question's been asked, I've actually found the opposite to be true. And I think that because the Family Division has specialist High Court judges that are used to dealing with finance, used to dealing with family, I think they're a lot more familiar with the subject matter, both in terms of the law, but also just from a human perspective. So, for example, if there are claims that involve allegations of dishonesty or they involve factual disputes which necessarily involve difficult cross-examination questions being asked, I've often found that the family judges are much less, I don't want to say forgiving, but they're much more ready to make adverse findings against witnesses, whereas many judges, both in the Central London County Court doing the business and property work and in the business and property courts proper, I think they are less likely to reach those sorts of conclusions just because it is less common. And there's also just a sort of general sense in a lot of chancery work that you have to do quite a lot before you're considered to be as suspicious for being dishonest, etc. So actually I found it to be the opposite, and also in Chancery Division, I think, because there's not as much familiarity with the matrimonial principles, you can very often have a case where it will be a chancery judge or a master who has almost no experience in doing the divorce cross-check or looking at the divorce aspect of it. And that can work in favour of the claimant rather than the defendant, because the jurisdiction is so sort of wide. Lots of family judges, I think, perhaps hone it slightly more, dealing with more cases, whereas if you're a judge with a chancery background, that may be less likely. And it may be, I think, that it leads to slightly more generous outcomes. But fundamentally, it shouldn't matter. That the only legitimate things I can say about either is that I think it is right that the family division is slightly more efficient, and it is easy to get things to come on more quickly. They're a lot more flexible, whereas in the chancery division, because everything is listed for a CMC, it is quite hard to kind of manage the process in the same way. And equally, the business and property courts are easier because you have the use of CE file, which obviously makes everything a lot more straightforward. Whereas with the family division in London, for firms in London, there can be a lot of running in and out, and it can be a bit old-fashioned. So that is now 6 o'clock. Apologies that I did not get to answer all of the questions. There are some which I will do my best to send an email with an answer that are a little bit more bespoke. But thank you very much for joining us for the webinar. I'm hoping that is at least of some interest, and that even if you are able to just have a brief look at the case and it proves useful with a particular type of client, and I can see from the comments that some of you are asking questions about clients who are, for example, 80 years old, that it will at least provide you with a starting point for your thinking about how to move matters forward. Now, I understand that the webinar has been recorded. I am told that if you want a recording of it, you can ask for one and you'll be provided with it. I think it's also transcribed as well, although I'm not so sure about that. But in any event, certainly if you want access to it for whatever reason, then if you can contact Chambers and also the marketing team, and they'll be able to assist you with that. You can also contact me as well if you want to, and please feel free to email me directly. My email address is my name, it's all lowercase, oliver.ingham@freeview.co.uk. And yes, I very much enjoy receiving email inquiries, even if it is just a quick hypothetical question arising in this area. Please feel free to do so, as it's always interesting to see sort of what's going on and what type of claims are out there at the moment. So thank you very much, and please do consider joining us again at our other events, which we advertise on our website and also on social media. And I believe you can also subscribe to our news thread on the website, which will provide you with updates. You can also select the practice areas you're interested in. So as between the various practice groups and chambers, I think we have basically everything covered. But in particular, if you are interested in private client work, then there's the property and estates group. And there's also the family law group sometimes do presentations and webinars about family finance, which will be relevant to this area. So thank you very much. And hopefully I will hear from at least some of you. And I look forward to doing so.